She began her legal career clerking for then Judge Neil Gorsuch on the United States Court of Appeals for the 10th Circuit. She then went on to clerk for another North Carolinian, Judge David Sentell of the D.C. Circuit, as well as for Justice Clarence Thomas of the United States Supreme Court. While a partner at Williams & Connolly, in 2019, Judge Rushing was nominated for and confirmed to her current seat on the Fourth Circuit. Staying true to her roots, her chambers are located in Asheville, North Carolina. Guiding today's discussion with Judge Rushing is Kannon Shanmugam. A partner at Paul Weiss, Mr. Shanmugam chairs the firm's Supreme Court and appellate litigation practice. He is no stranger himself to the Fourth Circuit, having clerked for Judge Michael Ludig before ultimately clerking on the United States Supreme Court for the late Justice Antonin Scalia. Mr. Shanmugam has also served in the United States Solicitor General's office and has built a career as one of the nation's foremost Supreme Court advocates, having argued 38 times before the High Court. As I told Judge Rushing on my last day clerking for her, I believe she embodies what Alexander Hamilton had in mind in Federalist number 78 when he spoke of a judiciary that exercises not will, but merely judgment. We're delighted to have both Judge Rushing and Kannon Shanmugam with us today. Please join me in giving them a warm welcome.
Thank you very much, Greg. I'm Kannon Shanmugam. It is a great pleasure to be here and to see so many of you here for this conference. And I am just personally so thrilled and honored to have this opportunity to chat with my former colleague, Judge Rushing. You know, whenever I get asked who is my favorite associate of all time, I always say my associates are like my children. I love them all equally. But, you know, the fact of the matter is that there is no one dearer to me who I've worked with over my career than Judge Rushing. So what a pleasure and privilege this is to have this opportunity to chat with you here. Judge Rushing, we're going to talk about your career, what it's like to be a judge, your experiences on the Fourth Circuit. But I think I would be remiss today if I didn't start by asking you about things in Western North Carolina in the wake of the hurricane and what it's been like for you and all of the people who are near and dear to you over these last couple of weeks.
I appreciate that, Kannon. Thank you. And thank you to Judge Numbers for starting us off today with that moment of silence for Western North Carolina. I deeply appreciated that. The short answer for us is my family was very fortunate. We are safe and okay. There are lots of people who are not, and it's going to take a long time. I'm glad that I get to go home there after this. And the court family, the Marshal Service, everyone has been incredibly supportive and helpful in getting resources to our area, to the courts, so that the federal courts can keep functioning in our area. We have great leadership with Judge Reidinger there in the Western District right now. So, you know, people are strong and resilient and are moving forward, but it's going to be a while.
Well, it's really wonderful to say that. And I know I speak for everyone outside North Carolina when I say that our thoughts and prayers have been very much with everyone there who has been suffering in the wake of this terrible tragedy. We're going to start by talking about Western North Carolina and your roots there in Henderson County and Hendersonville. Tell us a little bit about your upbringing, and in particular, tell us a little bit about why you decided to become a lawyer.
Oh, okay. But let me say this is fun to talk with Kannon. He's my former boss, then former colleague after that, and we actually haven't had a chance to catch up in a while, so I'm glad you all could be here for it. But it's really a chance to just chat with Kannon.
We're going to turn to our kids in a little bit.
Yeah. We'll pull out the baby pictures.
Let's go all the way back to your childhood. Yeah. We can go back even further.
No. So I'm, as Greg mentioned, I'm born and raised in Henderson County, North Carolina, which is just south of Asheville. My dad was a builder and then became a teacher. So both my parents worked in the public school system there pretty much my whole childhood, where my brother and I attended. It was in high school that I first learned about the possibility of being a lawyer, met my first real life lawyer for the first time. I'm the younger child, so I did whatever my brother did, and my brother participated in moot court or mock trial in our high school. I'm sure many of you here are familiar with what was then called the Wade Edwards mock trial competition, named after John Edwards' late son. And there was a program in high schools across the state, and you would get a packet of information and enough legal knowledge to argue your case, right? And students played the roles of witnesses and of attorneys. And an attorney in town was our advisor. So that was my first time meeting a real attorney. And it was my first time applying the law to the facts of a case to try to persuade a decision maker. And it was thrilling. I was totally hooked after that participation in mock trial. Virginia Haynes, God bless her, she's the history teacher at East Henderson High School, and she's the reason that we had a mock trial program, and it was wonderful. So after that was my first experience thinking, I like what lawyers do. I might be interested in pursuing this. That lawyer who advised us very graciously let me come and, do whatever I could do to be helpful around the office in the summer times. So I learned to trace real estate titles and, make photocopies and all the things anything I could do to learn what that lawyer's office was doing. And that was kind of my first window into the work of a lawyer, into what I might want to do one day.
So I have to ask you, I do know the answer to this question. So knowing that you might want to be a lawyer, what did you major in college?
Obviously, Kannon, I majored in music.
So let's talk about your other passion. So you were just sitting there thinking, this is going to be the ideal preparation for law school.
Well, to be fair, I double majored in music and political science.
So the political science half had you covered.
That's right. But it was, speaking of things that are thrilling, being in a courtroom trying to persuade someone is pretty exciting, but also being on stage with a captivated audience as a performer is pretty engaging. So I enjoyed music. I think my parents were glad I had the backup of political science just in case. But I was at Wake Forest. It was a wonderful experience for me to do my undergrad there. And I was always kind of going back and forth in my mind between, do I want to go to conservatory or go to law school? And I think my practical brain won out, and I think I made the right choice. Well,
I can, having, among other things, sat behind you in church, I can attest to the power of your singing voice. Though I was thinking of you the other day when Judge Jennifer Elrod became Chief Judge of the Fifth Circuit, because it's kind of remarkable that there are at least two Federal Court of Appeals judges who are, incredible singers.
Didn't the Fifth Circuit during COVID, didn't they have a performance that they videoed? Do you remember that?
Yes, there is actually a YouTube video of Judge Elrod singing. I don't know if there are any YouTube videos of you, but
I hope not.
All right, well, I'm gonna go back and check when I get back to my room. So after that, of course, Duke Law School, and then, as Greg mentioned, 3 extraordinary clerkships. But I think I want to ask you in particular, since we're here in North Carolina, about just the legendary Judge David Santel, who is really one of North Carolina's sort of finest legal sons, and what that experience was like.
All of the judges I had the privilege to clerk for were obviously brilliant jurists, and it was a real gift to be able to work for each one of them. But Judge Santel was a real inspiration to me, particularly because he's from Western North Carolina. He's from not far at all from where I live and grew up, and he has the accent to prove it, that he's a man of the mountains. And it was very inspiring to see that that someone who came from where I came from could go on to do what he's done. And he's been such a public servant, right? He was an AUSA. He has done it all. He was private attorney, state judge, district court judge, and then on the DC circuit. And then didn't stop there, right? He's been on the FISA court. He was the division for appointment of special counsels, and then many roles on the judicial conference, including chairing the executive committee. And I list all of that to point out that a lot of these other things, being on the executive committee, the judicial conference, you don't get extra pay for that. That's not something he did because you get additional attention or pay. It's a lot more work, and people take it on to serve the judiciary, to serve our nation. And he, to me, is just an epitome of someone who has devoted their life to serving our nation, serving the law, and he has done it all without an ounce of pretension, and is a constant inspiration to me and to, I know, lawyers and judges throughout North Carolina.
Yeah, I've had the chance to get to know him over the years, and he is not just one of the, finest jurists around, but just you could not meet a funnier, more humble, lovely human being than Judge Sentell.
If you haven't read Judge Dave and the Rainbow People, let me urge you to please go find a copy and read it. He wrote it about a case he had as a district court judge in Western North Carolina. It will interest you as a lawyer, and it will make you belly laugh with what he encountered in real life in the woods in North Carolina.
So, and then after that, having clerked for a future Supreme Court Justice in then Judge Gorsuch, and then for Judge Sentell, you clerked, of course, for Justice Thomas, and what a great experience that must have been as well. Yeah,
Justice Thomas is a man of unparalleled integrity and principle, and it was an incredible learning experience to work for him, both learning about the law and a lesson in character and principle, really. Obviously he's so brilliant, and you all know that because you can read his opinions, but getting to know him personally, get a little window into who he is. He's a man of deep, unshakable joy and faith and love. It was almost maddening as a clerk, we would go out to lunch. This was back when Supreme Court justices could just walk out of the building and go to lunch. And so it'd be 4 clerks and the boss, and we'd walk out to get some lunch, and on the way back, someone would want to stop and talk. I remember in particular, one time was a little boy and his caregiver who was with him. And the justice stops, he stoops down, he's listening, he's laughing, he's talking, and this just goes on and on and on. And the clerks were looking at our watches. We're thinking, we have work to get back to. Work is so important. But the justice, the work to get back to was the furthest thing from his mind. And it was always that way. It was almost impossible to get in and out of the building with him with any expedition, because he knew everyone and knew their stories and wanted to talk and listen. And it was a great learning experience in that way, in addition to, of course, his brilliance with the law as well.
So I'm going to ask a question I don't know the answer to, which is that, Judge, I'm curious, when you finished with Justice Thomas, did you at that point in your career think about coming back to North Carolina?
That's a good question. I think I always thought about coming back to North Carolina. But then you got a hold of me and turned me into an appellate lawyer, which I didn't know if I could do here anymore. But I've always, to me, and I'll say this about Judge Sentell as well, when I moved to D.C. to clerk for Judge Sentell, I very much felt like a fish out of water. And he was very comforting in that way to say, you belong here, and to help me learn the ropes. So I've always thought of myself as a Western North Carolinian who belonged here, and any opportunity to come back was always considered.
Well, I want to apologize for being a corrupting influence by making you spend a few more years inside the Beltway, but let's fast forward. We're going to skip past our years working together and the least interesting part of your career, and talk about your being nominated to the Fourth Circuit. So if it doesn't cause too much PTSD, let's talk about the nomination and confirmation process for a little bit. How did you come to be nominated, and then what was the confirmation process like for you?
I think I lucked out. It's, as someone mentioned already when talking about Tom Farr, it's become a very ugly process. And I think I mostly got out of it relatively unscathed and unjaded compared to what a lot of people have to endure. The process in North Carolina, I think, had been going on for a while, and I just happened to raise my hand at the right time. I have zero knowledge of politics. I never worked on the Hill, never worked for a senator or anything, so it was kind of it was a quick adjustment to learn all the political ins and outs of how this works. But I will say, I was very impressed with all the lawyers who I met along the way, the lawyers who worked in Senator Tillis's and Senator Burr's office, the folks in the White House, just incredibly talented and smart lawyers, and I enjoyed talking with them about the law. And so, that part of it was pleasant. The confirmation process, my nomination was held over, it had to be renominated. I believe my confirmation hearing was relatively uneventful. It's not one of those, if you look it up, where there's any interesting Q&A back and forth, because I think it was the first day that they started boycotting the timing of the event. So I showed up, and I think there were only 2 senators there, which was great. So it was pretty quick. We were in and out. We went and had some Chick-fil-A and called it a day.
Well, so you get to the Fourth Circuit. At the risk of saying something ungentlemanly, you were, I think, 36 at the time, though, as I told anyone who asked, you were the oldest 36-year-old I knew. And you're joining this court, which, included some people who are probably twice as old as you were. Tell us a little bit about the adjustment to being a judge, setting up your chambers, getting started as a judge.
I have wonderful colleagues, and they were such a welcoming group. Speaking of, colleagues who are twice my age, I think on our court, we're kind of known for our special collegiality, right? Both within the court and without. We have this wonderful tradition where we come down and shake hands after oral argument with counsel to kind of emphasize the cooperative nature of what we're doing and trying to find the right answer under the law. And on our court, it's the most senior judges who are teaching the rest of us how to interact and disagree with grace and kindness and respect. And it's not in any overt way. There's no manual that you receive on these sorts of things, but we learn it by observing them working together. So, Judge Wilkinson, Judge Niemeyer, Judge Kannon are judges who have been there a long time and have worked together, had disagreements, and worked through them. And it's hard to imagine the court without them. And I think I learned a lot from observing how they work together, and how I should be behaving as a judge, both with my colleagues and with counsel. I argued in front of these judges. It's still hard for me to call judges who were there when I was a lawyer anything other than judge. So I call some of my colleagues by their first names, and some are still judge. But they were very helpful as I learned how to handle things from that side of the bench.
So tell us a little bit about how you run your chambers. I know that you've got some former clerks here, some future clerks here. Just give us some insight into the mechanics of how you go about doing your business.
Sure. A judge's chambers is like a very, very small law firm. It's just me and the clerks and my assistant. I include the clerks in most of what I do. So many of you may know the Fourth Circuit. We hear oral argument only in a very small percentage of our cases. So 80 to 90% of our cases are decided on the briefs. And those have a different track for how they're handled than the orally argued cases. I include my clerks in helping me with both sets, because I think that gives them a fuller understanding of what really comes through the federal courts. They get to see employment discrimination cases arising out of state law, in addition to the high-profile First Amendment case or whatever that gets argued. So the clerks help me with all of those things. And, you know, a lot of it is informal, chatting in the office. It's not a big place. And then they give me a lot of written work product that we work through together as well. But I let them choose when it comes to oral argument cases, how they divvy up the cases, you know, aside from conflicts, obviously. And so it's enjoyable to work with them on cases that they're excited about. The clerks are always excited about every case because they're new, they're fresh out of law school, and I love getting that perspective every time I turn to a new case and work with my clerks.
And since I know there are a lot of law students here, what do you look for in a law clerk?
You know, I think what every judge wants, right, is someone who's smart, they're a quick study, they're a great writer, I like a self-deprecating sense of humor, and someone who's going to be easy to get along with. As I mentioned, Chambers is a small place, and so being someone who's willing to volunteer to help out, someone who, as I mentioned, has a sense of humor, who can work under pressure. You know, back in practice, you would think about, do I want to go to trial with this person? Or is this someone who I want to be in the war room with, you know, at all hours of the night when things are stressful and we're all tired? Can they still get the job done and have a sense of humor? So I think, you know, those are the folks who make great clerks. I've been very fortunate to have wonderful clerks every year, and they make the job, they help me do my job better, and they make it more fun and more interesting, for sure.
So even when you were a baby associate judge, you were a beautiful writer. So tell us a little bit about the opinion writing process, how you go about crafting an opinion.
Well, thank you. I appreciate that. I usually have clerks write a first draft of an opinion. We talk about the case ahead of time, and they'll write a first draft. And then I do to them what you used to do to my writing, which is just completely rewrite it with no red line and just send it to them revised and let them figure out, you know, they run the red line and figure out what I liked and didn't like. That's the Kannon Shanmugam mentorship
I just always
school.
thought it felt rude to send a red line. It just felt a little bit uncouth. Or better to, you know, just let them figure it out.
So I follow that model. And we go back and forth with the clerk who's primarily responsible until we settle on something that we think is right and accurate and generally in the shape we want. And then it goes to all the other clerks in my office. So everyone who's not recused works on the opinion to give us their insights. It's very helpful, I find, to have clerks who didn't work directly on the case read the opinion and tell me if they found something confusing, it wasn't clear, if they think we need to rework a section or something's not convincing. So everyone is involved, which makes for a better
that's
product.
Something that I know Justice Thomas does in
Exactly.
his chambers.
I learned that from Justice Thomas in his chambers. And, you know, and he's really my example for writing. I think he's a very clear and persuasive and accurate writer. I'm not... there are, you know, I clerked for Judge Gorsuch, Justice Gorsuch, who's, you know, well known for his writing style. It's very beautiful. He also bled red lines all over my work, and he's an excellent writer. But I find it difficult enough to get to clearly and accurately state what the court is doing and why we're doing it in a way that can be understood by anyone who picks up the opinion, and that's my goal. Justice Thomas has a great saying that the brilliance is not to put a 5-cent idea in a $10 sentence, but to put a $10 idea in a 5-cent sentence. So that's what I'm trying to do. I'm not trying to land any witty one-liners or, you know, brilliant metaphors. I remember as a lawyer being on the receiving end of some opinions that I'm sure the judges thought were clever, but when you lose, it doesn't look so clever. So I try to avoid that.
Yeah, I was going to say that I, you know, as an avid reader of your opinions, they are without artifice, which I think in many ways might be the highest compliment.
Well, thank you. I don't know enough to put on an artifice, I think is the answer.
Well, and that brings me to a related subject. So I don't think it'll be lost on this audience that you find yourself sometimes in dissent on today's Fourth Circuit. And one topic that I know that we've talked about in other forums is how you go about deciding to write separately. And I'll sort of ask you that question with two parts. First, when you're on a panel of 3 judges, but then when you are hearing cases en banc. How do you decide when you're going to kind of swallow your views, and how do you decide when you're going to you feel strongly enough about something that you're going to write separately?
Well, you may have noticed I don't swallow my views a lot. If there is a reasoned opinion, now again, our court decides some cases with opinions that don't have a lot of reasoning. So cases that are unargued may be a very brief, to the point opinion. And that has a different calculus, I think, for whether you think it's worth noting a dissent. But by and large, if there's a reasoned opinion, if I disagree with the bottom line, I'm going to dissent. I think that's my obligation. Now, how much you say and what you say may vary, whether it's a fact-specific case, right? I just think the majority has applied the law incorrectly to these particular facts. You can point that out pretty quickly. But there are instances where if you disagree with the legal principle, they're going to say more. There are times I'll say when I agree with the bottom line, but disagree with the reasoning, right? And that has a different calculus for writing separately. If it's a legal principle, or I'm concerned about how it's going to be applied in the future, or there's a national conversation going on, those are all reasons to explain more why you disagree with the reasoning, even though you agree with the bottom line, or the use of our court's precedent going one way or the other. But I have a drafts folder that has more draft separate opinions in it that have never seen the light of day, because sometimes you agree with the bottom line, but you disagree with the reasoning. And as I whittle the opinion down to really get to just the one kernel of why is it that I'm writing separately, then it seems that's not important enough to have a separate writing. I feel an obligation up front in a separate writing to explain why I need to write separately. I don't feel the need to write separately just to have my voice heard, to say, well, I would have put it a little bit differently. On our court, the tradition is that the majority author has a lot of leeway to write the opinion the way they want. And if I agree with what they say, even if I would have maybe put it differently or emphasized a point differently, I will join. But I'm not shy about writing separately if I can't join that reasoning. Now, when it comes to the en banc court, we can get lots and lots and lots of opinions. So there's a little bit of a different calculus, I think, just if someone else is saying something that I can get on board with. I recently wrote separately in our Second Amendment cases where there were lots of opinions, but in at least one of those, I felt there was no opinion articulating what I think is the approach that the Supreme Court would have us take in these cases. And so I tried to, as briefly as possible, set out what I thought was the right point of view and how I would decide the cases myself. But you have to, in humility, acknowledge that there's a vast menu to choose from of opinions in those cases.
So I'm curious what you think about, now that you've been a judge for 5 years, what you think about the use of en banc and the en banc process.
I think it probably used to be used less than it is now. We have a rule that articulates when it's appropriate to go en banc. So we have a rule that says if it's a question of exceptional importance, or your case has been inconsistent with our circuit's precedent, or is inconsistent with precedent from the Supreme Court, or is part of a circuit split, that those are reasons to take a case en banc. Obviously, whether a question is of exceptional importance is really in the eye of the beholder. So the en banc process can be helpful in certain cases. In other cases, you're adding 12 more judges to the mix doesn't always improve the outcome. But I think our court, we try to be careful about making that call. There are plenty of cases where a poll goes around and en banc review is not granted.
Do you think, I've heard judges on other circuits say that sometimes they find that en banc review can be divisive. You're reviewing, the work of your colleagues. Do you get that feeling when you're sitting en banc?
I don't. It can be when a poll is called. So it is when, another judge says, I want to see if everybody else wants to take this case en banc. That part has maybe could potentially feel divisive because you're voting, to say, well, I think we should reconsider what my fellow jurist did. But once you get past that point and the panel opinion is out the door, we're starting again with the en banc court, I think then we're all just really trying to do our best to find the right answer under the law, all 15 of us. So I think once we get past the poll, it's you don't have that lingering sense of judging the past panel.
One of the dangers of having an appellate lawyer moderate this is that this can get nerdy very quickly. But I'm going to ask one more slightly nerdy question, which is, how do you feel about the use of unpublished opinions?
Our court uses unpublished opinions a fair amount because we decide so many cases without oral argument. We have a rule that prohibits us from publishing if we didn't hear oral argument. We waived that rule for a brief period during COVID, but now the rule is back in place. As a judge, I am not at all bothered by an unpublished opinion. I think it helps some of us get our work out the door. And in a case that's not setting a precedent, not changing anything. On the other hand, as my clerks will know, I sometimes have a little soapbox about how even cases where you're just applying the law to the facts are worth publishing, often because in many areas of the law is advanced by individual data points, right? It's not that each case has to set some brand new principle. It's how does that principle apply in this set of circumstances or that set of circumstances? And it can be surprising to find out that, our circuit doesn't have a lot of published authority on certain issues. And so I think I generally favor, if I'm going to have a default, it's a default to publish because I think these individual data points are useful in setting out parameters for lawyers and judges in the next case to come down the road.
And I'm curious about your perspective on oral argument now that you've been on the other side of the bench for a number of years. What are you trying to get out of oral argument?
Well, attorneys will often ask if oral argument makes any difference. And I can say at the Court of Appeals, it does. As a lawyer, I wondered that. It often felt like you're just going through the motions. Like, they've read my brief. Why am I here? How can I survive the next 20 minutes without making an inappropriate concession? But on the other side of the bench, I will say oral argument can make a difference. Obviously, we have read the briefs. We've done our research ahead of time. And I think I and most of my colleagues come into oral argument with a sense of what we think we should do in any case. But some cases are closer calls than others. And sometimes you come in leaning a certain way, but how oral argument goes can persuade you. And, I've sat around the conference table with colleagues and we all said, well, I came in leaning this one way, but, then the attorney made this good point or conceded this point. And, now I think I'm going to go the other way. So I think oral argument really can be pivotal. In some cases, it can change the judge's mind, but in every case, it at least has an influence on how the opinion comes out. So when I go into an oral argument, sometimes you have a question that legitimately it has not been addressed in the briefs, a question that you don't know the answer to that you want to find out. Often, the questions that the judges are asking, we're trying to tease out the most important principles in the case, the limits of any party's argument, right? This is the dreaded hypothetical. I know it's not your case. I'm asking about a hypothetical case because we want to see if the principles that each side advances, how far would they go? What is going to be the implication for the next case, right? So often questions are along those lines. And, in the Fourth Circuit, oral argument is often the first time we've heard from our colleagues and what they think about a case. More often than not, judges don't discuss the cases ahead of time. There's no rule against it, but many judges prefer not to. So at oral argument, I hear for the first time what some of my colleagues' questions are, what their concerns are, and that can shape the whole panel's approach to the case as well. I hope that gives you some comfort if you're an attorney who argues in the Fourth Circuit and, one of us goes on a monologue about our thoughts. That really is helpful and informative in helping all of us understand each other's positions. Sometimes we're talking to each other in addition to talking to counsel.
So you have now been doing this for 5 years, and I'm curious how your perspective on the job has changed, or sort of how you sort of think about the job now as opposed to how it was when you first joined the bench.
Yeah, it's no surprise, I guess, that when you join the bench, especially in the appellate courts, it's going to be a little bit monastic, a little isolated, but that's something that took some getting used to, I'll say, from coming from private practice where you're working with a team of lawyers and there's constant discussion, about the case and figuring out the right angle and how to best write it and persuade. Moving to the bench where, as I just mentioned, most of the time we don't talk. I don't talk with my colleagues beforehand. We hear oral argument, we conference, and then we all go back to our home states and, we exchange some letters, we might have a phone call, but there's not a lot of discussion, or not as much as I would have thought as a lawyer on the other side of the bench. And so that took some getting used to. I have my clerks who are forced to discuss these cases probably longer than they would like to. They fill the void for me. But that, I think, has been the biggest adjustment, is just getting used to the different atmosphere on the other side of the bench.
And maybe in a related vein, and maybe you've just answered this question, what surprised you the most when you became a judge?
Yeah, I think it's the lack of discussion amongst the judges. Every judge I clerked for when I was a new lawyer, they were in a courthouse with other judges on their court. So Judge Gorsuch was with Judge Timkovich and Lucero out in the 10th Circuit. DC Circuit, obviously they're all together, Supreme Court all together. So being individual judicial outposts without your colleagues around it's a different atmosphere and took some getting used to. But so that was a bit of a surprise.
Yeah, I have to admit that when I was a law clerk on the circuit level, that really struck me too. Part of it is that, as you say, on the Fourth Circuit, the judges are fairly geographically dispersed. So it's not like, say, the DC Circuit where the judges are just down the hall from each other. What would you say to a young person who is interested in potentially one day becoming a judge?
I would encourage them. It's, for all of our complaints about the process of getting there and the difficulties of doing it, we need good, principled people to do the job. And it's a very rewarding job to be in the service of the public, serving our nation, playing a role of the third branch in our separation of powers, right? Having the responsibility to hew to the written law and preserve freedom and equality by applying the laws that the legislature has enacted to each person equally without fear or favor. It's a real privilege to be able to serve our nation and to serve its citizens in that way. So I will say, I think, being a great judge, from what I have seen in my few years on the bench, appears to take a lot of hard work and extensive preparation, but it also takes a measure of humility to stay within the judicial role. Our role as judges is not to impose our will in any given case on the parties, or if it's a nationwide injunction, on the nation. Our role is much more circumscribed. It's much narrower, and it's applying the law as it's written, or as it's come down to us in the common law, to the case in front of us, equally to each party, fairly, rich or poor. And I think it takes a measure of humility to stay within that role. It's not a role of writing the law as we think it should be done. And it takes some humility to, in any individual case, to acknowledge what we don't know. Especially in the Court of Appeals, we receive a limited record. We don't always know everything that's going on in the case. The lawyers make strategic decisions, and we can kind of sometimes get into a bit of trouble when we wander outside of that and assume we know things that aren't given to us. And then on a multi-member court, it takes humility to work together. I never get to just decide what I think is the right answer in a case and decree that that is how it shall be. I have other colleagues I have to work together with, and it takes humility to listen to each other's positions and honestly address their ideas. And so I think I would advise someone who is interested in being a judge that it's a noble profession, and you should approach it with humility.
So in something of a related vein, we're obviously living in a very politically polarized time. And as you know, there's been an enormous amount of criticism of the judiciary, of the Supreme Court, but also of lower courts. And, many of those critics have just said, law, it's just politics by another means. What would you say to somebody who said that? Why isn't law just politics by another means?
I think that's a very misfortunate caricature and misunderstanding of our legal system right now. It's, from my perspective on this side of things, it's a total myth. I don't read a lot of news reporting about the law and legal opinions these days, but the little bit I do, I can tell you is not usually accurate. And unfortunately, there's a practice of always listing the president who appointed the judge, right, as though that, no matter the topic that the opinion's about, as though that's the most important thing that you can know about the judges on the panel. But, right, our framers, they thought about this, right? They designed a system that's purposefully intended to insulate judges from the waves of politics. That's why we have life tenure. That's why our salary can't be reduced. These things are important, and I think they actually do accomplish that purpose. It's not politics by another means. In my experience, of course, speaking for myself and then the judges I work with, we really are trying to apply the law the very best we can to the facts of the case in front of us. And we may disagree about how that works out. Most often we do agree. On our panels of three, by and large, are unanimous. I know members of the Supreme Court lament that, only a few 5-4 cases get a lot of attention, but many of them are 9-0. And that reflects the fact that everyone is trying to follow the law. And I think it's an unfortunate mischaracterization that judges are somehow making decisions based on politics of any sort. And, the people who know best how judges are making their decisions are lawyers, right? You have interaction with the court system every day. You're in court. We heard that beautiful tribute to Tom Farr earlier, that he, when he had a positive ruling or a negative ruling, accepted each with grace. And I think lawyers can be helpful to the public in this way. It's part of civic education, is teaching people about your experience with the courts, right? That, I make my arguments, the judges engage with it. Honestly, they're trying to figure out the right answer. And sometimes I win and sometimes I lose, but I can still respect the process and the integrity of our public institutions. I know you have spoken about that recently, and I think that's an important role that lawyers can play. It's something, I think personal interaction with the court system tends to dispel this myth. Our court has started we've done it in the past, but we seem to be doing even more of sitting in places other than Richmond. We'll sit at law schools and hold sessions there. And it's wonderful because the students get to see up close and personal how the judges are working. They see that the panel is prepared, that they're engaging with counsel, trying to figure out the right answer. And that personal interaction, I think, helps dispel some of these myths about, the judicial decisions being made based on politics or anything else. I think there's studies that show this with jury service, that after someone has served as a juror, they come away with a more positive view of the court system. They view the judge as impartial, the system largely aimed at the ends of justice. So this personal interaction helps foster confidence in our courts and in our public institutions.
So I'm going to ask another question I don't know the answer to, but I really promised that we were going to let you in on the conversation we'd be having if you weren't here. Do you read things that are written about you?
I try not to.
Does Blake read things that are written about you? Because my wife is my primary, sort of Twitter searcher for things that are written about me.
I don't think so. He reads a lot more about what's going on in the legal world, movements between law firms and this, that, and the other. He informs me about the legal scuttlebutt, but I don't think he's reading about me because unfortunately he has to listen to me talk about me all the time. So he gets enough of that, I think.
Yeah, so I'm curious, how do you keep up with what's going on in the legal world? Because obviously, the Supreme Court's issuing decisions. There are a lot of other things going on. Do you pay attention to that, or do you really only pay attention to it when it comes up, within the lane of particular cases?
Well, I think we do have to pay attention to what the Supreme Court is doing and what's happening nationally, whether it pertains to a case I have right now or not, because inevitably some case will come up that where it is relevant for me, either now or pretty soon in the future, or even, where it's not the exact topic, but it has tangential implications. And so my clerks help me do that. I think it's important for them to have a very broad lens on the law as well. So they help me keep up with what the Supreme Court's doing, with what other federal courts are doing. And then Blake is my knowledge about, the
law firm gossip.
That's right.
So we are going to throw the floor open for questions, and in a minute I'll invite everyone to come up to the mic and ask any questions you might have for Judge Rushing. But I have one last question for you before we do that. Tell us a little bit about your life away from the bench.
Well, let's see. My life away from the bench, I have 2 little boys. And that's pretty much my life away from the bench. They keep us very busy and entertained, and they're somewhere at a museum right now in Richmond, in Raleigh, enjoying.
I was going to say, having seen them in the lobby, they're not so little anymore.
Well,
Judge,
I know. In my mind, they're little Kannon.
Yeah, as parents, we always think about them that way. Well, without any further ado, why don't we throw the floor open? Our one request is if you could introduce yourself before asking your question, that would be very helpful. But the microphone is quite literally open.
Now's your turn to ask a question of the judge. The tables have turned.
Exactly.
No hypotheticals,
particularly
please.
For the advocates in the room, this should be irresistible. We're going to start on this side, then we'll alternate. Go ahead, sir.
Good afternoon. My name's Andrew Brown. I'm the General Counsel for the North Carolina Administrative Office of the Courts. And in that role, one of the things that I help oversee is what's called the North Carolina Judicial Fellowship, where we provide law clerk type assistance to judges, trial judges across the state. And one of the topics of conversations we often have is the level of deference between a clerk and their judge, right? Because the judge wants to get good objective insight, and they're not always going to agree on everything. So how do you like to balance that level of deference, or how do you guide and mentor your clerks to push back on you, but in an appropriate way?
Yeah, and I might just add one thing. I mean, obviously you were a law clerk to 3 judges, justices, all of whom I think are pretty confident people with strong views. If you were talking to the law students in the audience, what makes a good clerk, and how does a clerk sort of, disagree with the judge and not just be a yes person?
I will say I love it when my clerks disagree, because I have this worry that they will be they'll be trying to predict what I want them to say. So usually, especially for cases that are argued orally, the clerks prepare a bench memo, and I try not to taint the waters. I try to let them come to their own conclusions before I start hammering them with questions about the case. And I really enjoy it when we have this sort of back and forth where I'll say, well, what about this? What about that? And a good clerk is someone who will defend their position and hold their own, but they manage to do it in a respectful way. And the case is not, it's not decided and settled until it's decided. And so I appreciate that feedback, but then the clerks know once I've said, well, we're going to write it this way, then they're on board with writing it that way. But I think it makes for a better decision and a better opinion when someone has vigorously been defending the very best points on the other side. I don't want, and my fear is to have clerks who are just trying to, predict what do I think the judge would want me to do here. And so I think I value that a lot and look for that in clerks.
Do the clerks sometimes change your mind?
I think so, yes. I'm trying to think. I can definitely recall at least one case where the clerk said A and I thought B, and eventually I think I found them persuasive. So yeah, it can happen.
Okay, one case in 5 years. That's not too bad.
There might be more.
Question over here.
Good afternoon. Jason Strickland of the firm of Wharton Smith and the Wade County Bar. It's hard to turn the litigator off, so with your permission, I will refer to you as Your Honor. Your Honor, do you have any good war stories about things that attorneys practicing before you, either in their briefs or their oral arguments or their motions practice, doing things that they clearly think are clever, but that you and the other judges just hate? Thank you.
You don't have to name names.
How long do we have? No. I will say one of my pet peeves is name calling, and I'll give you illustrations. Right? There was a paragraph in a brief, and in one paragraph, the attorney managed to call the other side's argument ridiculous, preposterous, just a string of adjectives. Disparaging the other side with no real substance. It's one thing to point out the fallacies in the other side's reasoning and to be descriptive in doing it, but it's completely unhelpful to just call the other side's position bad names. It's not persuasive, and more often than not, it makes the judge think, wow, you've really got nothing to say other than to call the other side, disparaging names. And I see that it's not every brief, but I see it more than I'd like. And I would like to see more substance and less adjectives.
All right, yes, sir.
Ned Headley, Hamilton Lincoln Law Institute, Wake Forest, class 91, so go Deeks. In your backyard, the Western District of North Carolina just issued the chief judge there an order about generative AI. And so I was wondering, as one of the younger judges on the federal bench, what your thoughts were about the use of generative AI in terms of like brief writing, where you might see that in the future. And also, as a father of 3 boys, you will be seeing it with your schoolwork or your son's schoolwork. So just your thoughts on that.
So any temptation to substitute AI for your law clerks, or is that still a few years off yet?
Well, I will say, although I'm a relatively young member of the court, I'm maybe one of the diminishing number that still uses hard copies. So I'm not really on the forefront of any of the technology that's at our fingertips. But it's an excellent question, and it's something that the court is really, we are aware of and thinking about. I know a number of courts around the country have issued standing orders about the use of AI, and then some have had to amend those because we kind of forgot that things like Westlaw and other things we've been using for years involve AI, right? So finding the right balance and requiring, I think the Western District now requires an attorney certification of some sort. So it's on our mind on the Fourth Circuit as well. It's something that we've been discussing, but we haven't made any official policy statement on.
I mean, it is amazing how powerful these tools are. We used our in-house AI tool just as an experiment to summarize Court of Appeals decisions to predict whether the Supreme Court might grant review. And the results, once the AI tools were trained, were astonishingly good. I mean, they were not as good as a well-trained associate, but the delta was not as great as you might think. It really is kind of astounding how quickly the technology is developing. Another question over here.
Hi, Hunter Bruton. I'm a partner here at Smith Anderson, a group focusing on strategic issues and appeals. First of all, thank you both for being here. And also, just thank you both. I started my career back at Williams and Connolly about 10 years ago, and you both provided great advice then and throughout the years. And just like to thank you both publicly for being titans of the industry, but always making yourself available for younger lawyers as well. Similar in that regard, the Fourth Circuit has a lot of great programs, both the CJA panel, the discretionary panel, the amici panel. What's kind of your view on ways the court can improve access to those programs, perhaps utilize them more to help other young attorneys get kind of stand-up appellate experience in the courts? And encourage pro bono service for that matter.
Yeah, it's great to see you again. And I might just add another corollary to that, which is, for young lawyers who might want to be appellate lawyers, talk about the importance of pro bono and other opportunities.
Absolutely. You mentioned CJA and all of those opportunities. Our court could not do the work we do without those attorneys. So we are incredibly grateful and indebted to attorneys who take on those jobs as well as many pro bono appointments. And if you come to court in that role, you will hear the presiding judge say, I noticed that you were appointed or you're taking this on pro bono, and the court thanks you because we cannot do our job without you. And it's really true. We are also nowadays, there's many instances where we need to appoint counsel to argue a position as an amici, as you pointed out. And there are panels now that are helping us find attorneys, especially attorneys who are relatively new to the practice, right, who are familiar enough with the Fourth Circuit that we are confident in entrusting a position to them. But we do want to give those opportunities to as many different folks as we can to increase the opportunity. I know you were a mentor to me in this and signing up for every pro bono opportunity, not only because it's my obligation as an attorney to use that degree and that ability to help people who cannot afford it, but also because of the opportunities that it gives you as an appellate lawyer and even as a trial lawyer. As it's harder and harder to get in court these days, and any opportunity to get in court and argue those motions is going to give you the confidence and the additional experience that you need down the line to get more and more of those opportunities. So I think you kind of taught me how to do that, and I try to direct my clerks in that way as well, if they're interested in going into trial work or appellate work, and finding a mentor who's willing to help you find those opportunities is also, I think, critical.
Well, and I do think that for those of us who are older and grayer, who are in private practice at law firms, that we have a real obligation to encourage our young lawyers to do that and to support them when they pursue those opportunities. Another question over here.
Yes, thank you both so much for being here. I think I'm one of those younger attorneys, Nathan Wilson, in appeals at Fox Rothschild. And as a younger attorney, as you were saying, one of the opportunities I get most often is amicus briefs. And when I talk to my friends, some of whom are clerking or recently finished, amicus briefs can be annoying at times, and I know that there's been a proliferation of them. So what advice do you have for those of us who are drafting? How can we draft amicus briefs that are helpful and useful and not driving some poor clerk crazy?
All right, amicus briefs, beneficial or annoying, Judge?
There's a wide spectrum. There are definitely amicus briefs that I have found very helpful. You don't want to repeat right? The parties' arguments. I tend to work sequentially through briefs. So if it's a 3-issue case, I tend to read each brief about issue 1 and each brief about issue 2 and can work through that way. An amicus brief, I can turn to the table of contents and decide if it's telling me anything new, usually. So if you can provide something new, whether it's an insight on, say, it's a question of statutory interpretation, and you have an angle on the history of the statute, right? Sometimes amicus briefs are helpful if they highlight implications of the court's ruling for another related area of the law. So maybe the parties are focused on their particular dispute, but the amicus wants to point out, if you rule a certain way, it's going to have implications in this other related context. Those sorts of briefs I find helpful, but a brief that just repeats the parties' arguments is not going to be useful. We get a lot of policy arguments. I personally don't find those very useful, but I'm sure some of my colleagues find them more helpful in some cases. I will say, try to avoid repetition, and someone will read it.
And it occurs to me as you say this, just because literally before I came down here, I was on a phone call with some potential amici in a case I'm working on, that the litigants have a real obligation to encourage the amici to come up with an interesting angle and not just to repeat the arguments they're making. Question over here.
David Bragdon with the U.S. Attorney's Office in Raleigh, North Carolina. Sometimes there is some tension between a really interesting substantive issue before the court, or maybe something with something that the court would be very sympathetic to, an equitable matter, and a procedural rule that prevents the court, or maybe should prevent the court from deciding that. And how do you think judges handle that tension? And the second part of the question is, when an attorney is briefing that and relying on the procedural bar, is there a way to sell that or present that in a way that's more palatable when you know that the court will really want to reach the substantive issue?
Yeah, maybe I'll just broaden that out a little bit. Do you have thoughts on sort of procedural rules, how courts apply them as you're sort of going about your work?
Obviously the court is bound by the substance of the law and these procedural bars, right? And representing the government, you have an obligation to help us reach the right decision, even if it's maybe not the way that you think the court would want to go. I always appreciate when counsel find a way to make the arguments that have to be made, and also the sort of fallback, and we would win on the merits anyway. Because you're right, you can't predict ahead of time what the panel is going to do, even if the panel agrees with you on the procedural bar, then there's no reason to move on to the substance. But obviously, it's in your interest to present both, because you don't know who you're going to get and what the panel's going to find persuasive. But there are many instances where if the attorneys don't make the argument, the court can't reach it. Some questions of jurisdiction, obviously, we can address on our own, but there are many questions where if the litigants don't raise them, we will not raise them sua sponte or cannot. So it's incumbent on the attorneys, if they think it's a persuasive line of argument, to raise it themselves.
Thank you.
And perhaps I'll take the moderator's prerogative and ask one last question, which is, how do you balance kind of the interest in getting it right and writing a lengthy or at least a thoughtful opinion with the need to provide answers to litigants sooner rather than later? Because in the appellate system, you don't really have deadlines when you're issuing your opinions. So how do you think about that?
I think that's a constant tension, is the need to get the opinion out versus the maybe more selfish impulse to linger to make it even better than it could have been. And we're constantly trying to kind of hew in between those two, right? To give the litigants the guidance they need to let the case move along, I try to make a priority of prioritizing cases where there's going to be further action, right? It's not the end of the line, and not spend too much time hemming and hawing over the beauty of the writing. Although you want to, obviously, if you're setting a precedent for future cases, you've got to be careful in how you write it. There are opinions I think about that I particularly enjoyed working on, not because of the outcome of the case, because as a judge, that's really neither here nor there, but because of the interesting issues and the complexity of the case. And I enjoy, it's pleasant to look back and think, oh, that opinion really grappled with the hardest questions on each side. And of course, from my perspective, handled it appropriately and came to the right answer. And there's some cases that you're just excited to work on because of the ability to grapple with those new and interesting questions before the circuit.
Great. I think we have time for one last question.
Thank you, Judge. Thank you, Mr. Shanmugam. I just had a question about judicial philosophy. Would you describe yourself as an originalist, or how would you describe your judicial philosophy? And are there any examples of where you've gotten to apply that, even at the circuit level, where you're bound by Supreme Court precedent?
Well, that's a nice, easy last question. I was going to ask you who's going to win the ACC this year, but instead, just 2 minutes on your judicial philosophy, Judge.
Well, I think probably thanks in large part to groups, to the conversations that this organization has spawned and to the jurists who have been inspired by it. Pretty much every judge in the country now has to at least look at the text, right? Whether we're talking about the Constitution or a statute, and has to address the text first. The conversation has really changed from decades ago. And so it's not at all unusual to find that every judge, I mentioned our court just recently had this trio of Second Amendment cases, and every judge on the court is trying to look at the text and look at the original understanding and come to the right answer. And so that it's just refreshing, right? That we all understand that those are the questions we're asking now. The Second Amendment is one of the very rare instances where the Court of Appeals has had the opportunity to engage in originalist work on our own. As you mentioned, the Supreme Court has addressed, by and large, most of the questions that would come to us from an originalist perspective. There's always nuances to tease out, but they've given us the wide parameters. And so I think for the Court of Appeals judges and our clerks, that has been a really fun area to work in because we have gotten to do some of that work ourselves. And then the court, of course, has been giving us guidance along the way now that cases have made their way up there. But that's an example of an area that we're getting to do it ourselves. I don't know that there'll be much, quartering of soldiers coming up anytime soon. That's the only other one I can think of that the Supreme Court hasn't sketched out for us. But if they do, I can't wait to apply originalist principles to the Third Amendment.
Well, we can't wait to see your first Third Amendment decision, Judge. But in conclusion, I just want to say two things. First of all, as somebody who has a deep affection for this state, but not necessarily for all of its basketball teams, Rock Chalk Jayhawk. I just want to thank you all for inviting me down here for this program. But second, I hope that the last hour has made clear how lucky North Carolina is to have one of the finest judges in the country in Judge Rushing. So thank you for joining us today. And please join me in a round of applause for the judge.